Warning, a revocable living trust does not protect assets from nursing home costs. Did you know that? A lot of people go to their attorney and they say, I want to do my estate plan, make sure I'm protected. And their attorney says, sure, let's set up a revocable living trust. We'll make sure that we avoid probate and minimize estate taxes. So, well, what about Medicaid? Well, when you spend all your money, you can qualify for Medicaid, right? They don't really think about it or know how to do it. But the revocable trust is not the solution to protect your assets from nursing home costs. And in fact, in some situations, your revocable trust can be a trap, trapping your assets and preventing you from qualifying for Medicaid. In fact, anything in the revocable living trust is a non-exempt asset, including your home. You know how your home was supposed to be exempt? At least for qualification, even if it's not exempt from recovery? Well, if your home is in the revocable trust, you cannot even qualify for Medicaid. They'll say, take it out of your trust, put it in your individual name, then it's an exempt asset and you can qualify. Until then, as long as it's sitting in your trust, you're privately paying, you can't qualify for Medicaid. Why? Because the state wants to put a lien on your home, and if the trust owns it, we have an argument that the trust is a separate entity, separate person legally from you, and the trust is not getting Medicaid benefits, you are. So if the trust owns the home, and the state puts the lien on there, we can argue that they have to remove the lien after you've passed away because the trust didn't get any Medicaid benefits. We actually did this successfully for 5 different clients who had a home in the trust, happened to slip through the cracks, get qualified for Medicaid, and the state put a lien on while the home was in the trust. And I think because we've done such a good job of saving these clients' homes, now they're very careful at the application process time, and they make sure that you do not qualify if your home is in the trust. They make sure you take it out, put in your individual name. What are the problems with that? 1, they put a lien on your home, and 2, when you pass away, it has to go through probate because it's not in your trust anymore. So it goes through probate, and then you still have to pay off the lien, maybe sell the home or whatever, or buy it back from the state before your heirs can get the house. So that's the one big problem with it. Here's the worst problem. If you are healthy and competent, you can still say, I'm going to give my assets to my spouse, right? You can take it out of your trust, you can give it away to your spouse. It's revocable, it's amendable, and you can control what happens to it. And as long as you have the power to give everything to your spouse, we can help you save 100% of the assets in almost every case. We've had clients with $600,000 in the bank, and within 1 month, we got one spouse qualified for Medicaid. The healthy spouse got to keep the other $600,000. You say, how can you do that? Didn't we have to get down to $119,000? Legally, we meet the requirements, but we have loopholes that help the healthy spouse save all those assets. So we've done it with $1 million. There are things that can be done. The problem with the trust is where it could become a trap. And here's an example of how. If you read these trusts, a lot of times I've seen them drafted by other attorneys, and it says something like this. During my lifetime, my trustee shall use my assets as I direct from time to time in writing, and in the event of my incapacity, my trustee shall use my assets for my health, education, maintenance, comfort, and welfare. Or something along those lines. Does that sound familiar, right? You see something like that in a trust? Almost all of them have something like that. Notice the problem with that is it says, during my incapacity, my trustee shall use my assets for my health, education, maintenance, support, comfort, and welfare. Shall means must, right? So anything in the trust, the trustee has to spend for your care. They don't have the option to take it out of the trust and give it away to your healthy spouse. Even if Medicaid would let you do that with no penalty, and we could come up with some loopholes to save all those assets in the healthy spouse's name, you can't do it if the trust says you have to spend it on my care. And a lot of lawyers prepare trusts like this without realizing that they're making a trap for Medicaid planning. In fact, I would say the majority of trusts that I review prepared by other attorneys have language like that. So what do we do in that case when someone came to our seminar and they say, I want you to look at our estate plan and see if there's a problem? We'll review it, and if it has language like that, we'll do a simple amendment that says, in the event of my incapacity, my trustee may use my assets for health, education, maintenance, support, comfort, and welfare, or my trustee may give it away to my spouse or children or other family members or friends so that they have an option to either spend it for your care or give it away to your family members. If it doesn't say specifically that the trustee has a right to give the assets to your family members, they're prohibited from doing it, and it's trapped in your trust and it has to get spent. In theory, if your home or half your home is in your trust and half is in your spouse's trust, in theory, if your trust said that it has to be spent for your care, that could even mean selling your home, turning that into cash and paying for your care, because as long as your half of the home is in your trust, it's not an exempt asset and it's worth more than $2,000, you can't qualify for Medicaid, even if you spend all your other money. If the trust doesn't allow you to give it to your spouse, it could be trapped. So that's the most important thing I will teach you today, is make sure you review your existing estate plan and in your revocable trust that there's the power to gift assets away to your family members or loved ones. Same thing with your power of attorney. Anything that's in the trust can be given away. Anything in your individual name, you have to have language in a power of attorney that gives someone authority to manage your assets for you that's outside of the trust. So the power of attorney is for things that are in your personal name. The trustee can manage anything that's owned by your trust. But your retirement accounts, IRAs, 401ks, those are personal to you. They're not owned by your revocable trust. And so we need to make sure your power of attorney also has the right language to be able to make gifts on your behalf once you become incapacitated and you can't do it yourself. Does that make sense? So if you remember nothing else today, this is the thing for you to remember in planning going forward.